Yes, I think you were going to take us to a different case now, Mr. Howells.
My Lord, yes. Just before I do, could I just mention the judgment of Lord Justice Sales in the Public and Commercial Services Union and the Minister for the Capital Office Divisional Court Decision 2017, England Wales High Court 1787. I don't need to take your lordships to it, but the way that Lord Justice Sales described the objective assessment in that case was that it involved an evaluation of the counterfactual world in which the identified unlawful conduct by the public authority is assumed not to have occurred. So the counterfactual world, in my submission, is a good way of explaining the function of the court when applying section 31(2)(a). If, in this case, if the Secretary of State did misdirect themselves as to the applicability of paragraph 2, schedule 2, is it highly likely that they would have used section 94(1) instead, which the appellant says is the obvious.
On that, I mean, I think it's quite interesting because it is an exercise of a different power, and we'll have to decide whether that's within it. But I mean, looking at the section 94, I would have thought if I was a boring judge and permissibly entering into the arena to make the decision, I would make the decision under 94B. But you tell me the Secretary of State wouldn't because she had guidance at that time which told her to use 94(1). Now, all I'm saying about that is that does that impact on what's highly likely to occur? And isn't this just a practical illustration of courts having to be very careful about assuming that just because we make the decision, because we have now spent a day trying to work out what these regulations actually mean, whereas the Secretary of State doesn't have that time, and she would have come to inevitably the same conclusion.
Well, your Lordship is absolutely right. I mean, the court does have to be conscious to make sure that the high threshold is met, and if there's any doubt about it, then 31(2)(a) should not be relied upon by the court. If there are doubts, now in respect of the particular doubt that your Lordship has asked me about, section 94(b), the policy guidance on revoking deportation decisions is in the authorities bundle. And it's in that guidance, it says that because of regulation 33 of the 2016 regulations, because it's materially the same as section 94B of the 2002 Act, the decision makers are not to use section 94B. Regulation 33, it's a duplication. Now, the guidance didn't think about every eventuality, but my instructions in this case were that 94B was not operational.
So is it part of your counterfactual world that the guidance is also corrected to eliminate reliance on Schedule 2, Paragraph 2?
Well, the counterfactual world is more restricted than that, in my submission. It's had that provision not been relied on, because it was identified by whatever means that it wasn't applicable, then is it highly likely that section 94 would have been used?
Yeah.
So
back to 94(1).
94(1), yes. My Lord, the second authority that I do wish to take the court to is Gathercole and Suffolk County Council, 2020, Court of Appeal 1179. May I take the court to page 391? So just looking at the head note for a moment, as I've already explained, this is a case about an officer's report that in relation to the design of a new school, and the issue was whether the failure to refer to the public sector equality duty impacted on children with protected characteristics, because they hadn't considered noise insulation because the school was close to an airport. At paragraph 34, paragraph 34 of the judgment, of Justice Coulson, page 406. conclusion about the public sector equality duty was that I've concluded that the respondent failed to have regard to the public sector equality duty in respect of the narrow point advocated by Mr. Streeton, namely that they failed to have regard to the effect of aircraft noise in the outdoor areas on children with protected characteristics. So the reason that I want to draw out those facts is that this is a decision where a duty had not been considered. So that function had not been discharged by the decision maker. The exercise the court had to go on to exercise is, well, if that function is discharged properly, what would the effect be on the decision? And so this is another example of the court stepping in and in its objective analysis, making judgments about a function, the exercise of a function which had not yet in fact happened or been discharged by the decision maker. May I refer the court to paragraphs 37 to 39. So after referring to Goering-on-Thames, which the court's already seen, Lord Justice Coulson says this: on the assumption that Mr. Streeton's complaint about the respondent's failure to have due regard to the public sector equality duty was well founded, Mr. Ground argued, in reliance on Goering, that the application for permission to bring judicial review proceedings on that ground should still be refused, because even if there had been reference to this issue in the officer's report, it is highly likely that the planning decision would have been the same. In response, Mr. Streeton said that the test of highly likely was a high one, and that it would be unfortunate if this court came to such a conclusion in a case like this, where there was a good deal of strong emotion. And paragraph 38 is important in my submission. It is important that a court faced with an application for judicial review does not shirk the obligation imposed by section 31(2)(a). Provision is designed to ensure that, even if there has been some flaw in the decision-making process, which might render the decision unlawful, where the other circumstances mean that quashing the decision would be a waste of time and public money, because even when the adjustment was made for the error, it is highly likely that the same decision would be reached. The decision must not be quashed, and the application should instead be rejected. The provision is designed to ensure that the judicial review process remains flexible and realistic. And then he goes on to say that, in my view, this case is a good example of the type of situation for which it was designed. The reason set up below, I consider that if there had been a paragraph in the officer's report flagging the point, explaining that the use of the outdoor areas was subject to all possible noise mitigation measures, that there was a potential residual issue for children with protected characteristics, it would have made absolutely no difference.
I mean, that's a relatively straightforward case, isn't it? There, and in Goring, you've got a decision by the decision maker to grant a planning permission. There it is, it's a piece of paper, it's the planning permission. The court is asked to quash the decision, i.e. to remove the planning permission. And the court says, well, if they'd taken the right balance of listed buildings into consent, or if they'd taken the protected characteristics of children into account, they would still have granted the planning permission. So, well, that's the decision that stands. Not so easy to apply it to this case, because the decision is a decision that Schedule 2, Paragraph 2 precludes a right of appeal. If relief were to be refused under Section 31(2)(a), we would not be certifying under Section 94, would we? We wouldn't be saying we certify that it's without manifestly bound to fail, whatever the test is. What would we be doing? We say it is as if the Secretary of State had certified.
So what the direct answer to that is, what the court would be saying is that it is highly likely, had the Secretary of State not relied on paragraph 2, Schedule 2, the Secretary of State would have certified the decision under section 94(1). It's a factual finding exercise about what is highly likely to have happened.
And therefore, although in principle the appellant did have an in-country right of appeal, nevertheless we decide that he does not. That's how it works, is it?
Nevertheless, we find it is highly likely that the Secretary of State would still have certified the decision under a different provision, so that the in-country right of appeal became an out-of-country right of appeal. And so like the Section 149 duty in Gatherco, which was not discharged by the decision maker, the court made the decision that had that statutory provision been discharged, it is a duty, had that duty been discharged, the effects would have been this. In that case, it wouldn't have made a difference to the outcome. In my submission, there's not much of a difference between that and this court saying that had the Section 94(1) certification been considered instead of paragraph 2 Schedule 2, it would have been exercised with the same result under Section 92, subsection 3, because both provisions feed into that, that provision, that the appeal is out of country. So the outcome, ultimately, whichever route you get to Section 92(3, whether it's via Section 94(1) or whether it's via paragraph 2 of Schedule 2, the outcome is that Section 92(3 applies and the appeal right is out of country, not in country.
Yeah, so
In
that,
both-
that
I mean, in
places
both
quite a lot
cases-
of weight on the word outcome in the section.
My lord, yes, and that's the point that I do make, is that the focus has to be on the outcome, and the outcome in this case is highly likely that the appeal right would have been out of country because of Section 92(3, the same provision, but via a different route.
What relief was sought by the claimants in this case anyway? Because it's not quashing a decision, it's just saying that in fact it didn't have the effect you thought it was.
May I just check
Because
whether a quashing decision, certainly a declaration was sought,
yeah,
the declaration wasn't granted, no relief was granted.
but you see, if suppose, I mean, because obviously we have to work out what we do think on all these things, but suppose we were against you on the first issue, and then you wouldn't grant relief, even though we've given a whole judgment saying that this is the effect of it. I mean, we'd just be declaring that this is the proper analysis of it. So it's not really a sort of 31(2)(a) situation. I mean, it ties in with, I think, where my Lord Justice Lewison started with you this morning, which was really perhaps the Secretary of State should have said, in relation to this ground, I understand why you didn't. Off you go to the tribunal and test it there, because if you had a right of appeal, you carry on, and if you didn't, you didn't.
So, I understand the point that's being made, that once you've got a judgment, then it's then for the courts to apply it. But of course, we're not, at first instance, in the Upper Tribunal, you're not considering an appeal. It was a claim for judicial review. And whether a claim for judicial review is successful or not is dictated by what relief has been obtained. So the question of relief may not make much of a difference in terms of whether the Upper Tribunal apply the judgment, whether take the example of the Upper Tribunal applying this court's judgment, but it's also what's the consequences for the claim.
Yes, well, I think the point you're making emphasises the importance of what I think you were about to do anyway, which is to show us the relief that was sought in the judicial review claim.
Page 263.
Grateful now.
It's 263 and 264.
Which were the bits that leave wasn't given on?
Rounds 2 and 3. So in terms of how that translates to relief, so quashing order is sought in respect of both decisions.
Yeah,
So-
can you help me on that? Because at the moment I'm struggling to understand that. Because when one looks at little paragraph 1, quashing the decisions setting out in letters dated 2nd June 2020, 14th July, contending that So it seems to me to be self-contradictory on its face, what was being asked for. Because a contention that someone doesn't have an in-country right of appeal is not a decision. And that reflects the fact that it's actually a question of law. And as I forget whether it was Mr. Cooper or yourself put it this morning, it's a binary question. It's right or it's wrong. You can't quash a contention, and it isn't a decision. So, speaking for myself at the moment, Little Roman 1 seems to me to make no sense whatsoever. Whereas the declarations sort do make sense, because what that's asking the court to do, particularly the Little Roman 2, is saying, well, what the law is as to do you have an in-country right of appeal or do you not? But if one focuses on that aspect of it, then it seems to me it's a little hard to see how Section 31(2)(a can bite. Because once the court has decided what the law is, in its judgment, how can you possibly say that there's conduct, the outcome of which will be substantially the same? I mean, it's all dependent on is the right view being taken of the law or not?
So, my lord, a declaration under Section 31 of the Senior Court Act has a special form of status as an identified remedy, the same as a mandatory order, the same as a quashing order. In this case, even though the Upper Tribunal came to a decision on the law, it refused to grant a declaration. So it refused to grant a remedy under Section 31.
But that's the bit I'm not understanding. And it may be to do with the status of the Upper Tribunal, but it comes back to the question my Lord Justice Lewison asked this morning, which is, if the court decides that as a matter of law, an in-country right of appeal is available, and the appellant then files his notice of appeal, what difference does the absence of a declaration make?
So it was open to the court to say that the judgment stands as the declaration. You don't actually have to have a separate declaration written out in an order. The court didn't even say that. The practical consequences are that in public law terms, public authorities are expected to implement declarations.
Sorry to interrupt, but I think we need to cut to the chase here. Are you saying that the first tier tribunal would be at liberty to disregard a decision of the upper tribunal as to what the law was because of the absence of a declaration?
My lord, no. The practical consequence of a declaration being made so far as the Secretary of State is concerned is that the Secretary of State would then be expected to revisit the decision, maybe withdraw it and remake the decision. But because that declaration was not made, there wasn't that expectation that flowed from a declaration on the Secretary of State. Now, that is not to say, and I accept your Lordship's point, the first tier tribunal, had an application been made to the first tier tribunal for an appeal, they would apply the judgment of the Upper Tribunal. But it's about what actions the public authority is expected to take in response. Because relief was refused and the claim was dismissed, the Secretary of State didn't need to take any further action.
But just following on from my Lord's question, you accept that were the appellant to issue a notice of appeal in the FTT could not ignore the decision of the Upper Tribunal, still less could it ignore our decision, assuming we're against you on the first point. There's nothing more the Secretary of State needs to do except resist the appeal, and presumably it is open to the Secretary of State at any time to certify under Section 94(1), or if she thinks fit under 94B, having revised her policy guidance, in which case the appeal grinds to a halt in country, doesn't it?
Lord, I agree. There's nothing required of the Secretary of State in terms of an appeal to the first tier tribunal.
Declaration doesn't make any practical difference, does it?
Had relief been granted, and had there been a declaration, the Secretary of State would have had to have withdrawn the decision. Is the
But
reality.
there wasn't any decision. I mean, I think this is the root of the problem. There wasn't a decision. There was a contention. I mean, to that extent, the relief sought was accurate. A contention had been put forward as to the correct legal analysis, and the gravamen of the challenge was you were wrong on the law. It wasn't a decision; it was a contention.
My Lord, what I mean is the whole decision of the 14th of July would have to be withdrawn, and the decision on appeal rights be remade, and a decision made under Section 94(1) of the 2002 Act. Because suddenly, the Secretary of State's been told your position on the law on paragraph 2, Schedule 2 is wrong.
I must say I find this bewildering. The claim that the Secretary of State was deciding was a claim made under the Human Rights Act, Article 8. The Secretary of State rejected that claim, and that's the end of that claim. That's the claim. I mean, sometimes, well, in fact, very often, an order is made in the county court, and the order says, if you want to appeal against this order, you appeal maybe to the High Court, maybe to this court, depending on what kind of case it is. That's not the decision. That's some information for the disappointed loser about what they can do next. The only decision was the refusal of a Human Rights Act claim.
My Lord, in my submission, if the Secretary of State were told that their understanding of paragraph 2, Schedule 2, as set out in the 14th of July letter, was wrong,
Yeah.
the intention of the Secretary of State, both in the 14th of July decision, but also back in November 2018, was to stop the appellant appealing in country. Now, in order to give effect to that intention, the Secretary of State would have to withdraw the decision of the 14th of July and remake it and certify it under Section 94(1). So there's a difference here between Section 94(1) and paragraph 2, Schedule 2. So I have made the point that paragraph 2, Schedule 2 is automatic. I mean, the consequences flow through the legislation. Under Section 94, subsection 1, it requires a decision to certify as clearly
I follow,
unfounded
but
in
I
order to stop
understood
the
it to
appeal.
be common ground that the Secretary of State can take that decision at any time.
No, at the time that the decision is made to refuse the human rights claim is when the decision to certify it would have to be made. Section 94B is different. Section 94B says on its face that it can be made at any time during the appeal. Section 94(1), the decision to certify as clearly unfounded has to be made in the same decision notice as the decision, so that the recipient of the decision notice knows whether they can appeal or not.
And can I just ask where in this sort of counterfactual world one puts in the reality that we all know from exposure to this sort of litigation, which is that with the passage of at least 2 years since well, it was 2020, wasn't it, of 4 years since this decision was made, there will be inevitably a new and different Human Rights Act claim. Whether it's enough to amount to a separate claim is a different point. Where does that fit in?
Well, as your lordship will know, that will just have to be dealt with on its terms, and I'm either certified or not, and it would depend on the outcome of your lordship's judgment.
Because this is all looking at a historic situation back in 2020,
Yeah.
and we all know that, assuming that he's been living a life since 2020 in the UK, there will be different considerations. They may not add very much. They may, my goodness, anyway, that will do this. So that what actually happens to this decision is pretty irrelevant now.
So my lord, if your lordship's with me in relation to the cross appeal, then the consequences for the appellant are automatic. If he makes another human rights claim, the appeal's still going to be out of country. He's now removable, and the Secretary of State can proceed and remove him. If the court is not with me on ground one, then each and every time a human rights claim is made, then a decision to certify under section 941 will have to be made.
So again, the declaration, whether made or not, doesn't seem to make much difference. If you're right on the cross appeal, that's the end of it. So we're only looking at section 31(2)(a) on the assumption that you're wrong. And if, as you say, he can make another Human Rights Act claim, which will then have to be decided on its merits, because, as my lord says, nearly 5 years has passed, 4 years have passed, what difference does a declaration make?
Well, it doesn't make any difference in that situation. I wish to be clear, and I hope I was in response to His Lordship, Lord Justice Arnold's questions. The section 31(2)(a) point is taken as a point about relief and about whether the claim was successful or not. I accept the points that your Lordship is putting to me. So actually, just wider consequences outside of the civil litigation, what's the difference between First Tier Tribunal just reading the Upper Tribunal judgment and giving them a right of appeal anyway? I mean, I completely take those points. The focus of the section 31(2)(a) argument is more about the actual consequences for the litigation.
Right. Who pays the costs?
Yes, ultimately, whether the claim is allowed or not, and then who pays the costs.
Yeah. All right.
Yeah, just so as we're clear about the point I was putting to you about the quashing order, I think we can see this from page 289. So this is the 14th of July 2020 letter, which I think is the relevant one, and it's really paragraph 41, and it's under the heading "Bringing an Appeal," and what it says is you may appeal the decision to refuse your human rights claim on section 82 as your decision to make a deportation order was certified under regulation 33 or human rights claim arises from the consequences of that deportation in accordance with paragraph 2, schedule 2. Your appeal right must be brought from outside the UK. So what that is doing, as my Lord Justice Lewison was putting to you, is it's giving the applicant, or now the appellant, information as to his correct route and mode of appeal. It's not a decision.
Well, I agree.
It's a legal analysis, and therefore the proper remedy was the declaratory remedy. But the declaratory remedy only gives effect to the court's decision as to what the right analysis of the law is.
Well, I agree with your analysis of paragraph 41. I don't suggest that that's a decision, and that's just the Secretary of State saying this is our understanding of the law. When I refer to the decision being withdrawn, I mean the whole decision letter, because if it's the Secretary of State's intention to stop an in-country appeal, and if they're wrong about paragraph 2, schedule 2, they would have to remake the decision, including a decision as to whether to certify it under section 94(1), just as the decision in November 2018 contained a decision under the heading Regulation 33, we are certifying your appeal under Regulation 33. This really comes down to the difference in how paragraph 2 and schedule 2 and then section 94(1) operate. Paragraph 2 schedule doesn't require a certification.
No.
Section 94(1) does require a certification, and that's why I refer to withdrawing the decision to allow that process to happen. But I agree that what's at paragraph 41 is not a decision in and of itself.
That's very helpful, thank you.
In terms of the underlying merits, it's a simple point. I don't need to deal with it in any detail. The only evidence that was filed was the 22nd of May letter, the mother's witness statement, which is only relevant to paragraphs 12 to 13, and that's at page 296 of the core bundle.
Well, I see that Judge Perkins decided in his order of the 5th of October that the claim on Article 8 grounds is essentially hopeless.
Yes, and both the decision maker and the Upper Tribunal said there is no evidence to support your claim. No evidence. And on top of that, you also have Section 117C of the 2002 Act, which is the codification of Article 8 considerations. in deportation cases, section 117C, which requires a person subject to the deportation regime who's relying on private life to show very significant obstacles to reintegration. And that's a high threshold. So that goes into the mix as well. In terms of speculation, in my submission, there's no speculation required. It's an objective requirement for this court, as it was for the Upper Tribunal. The evidence is available and the Secretary of State's decisions are available. Those are my submissions, Members.
Thank you. Yes, Mr. Cooper.
My Lord, just briefly in relation to section 31(2)(a), you've had a fairly detailed engagement on that, but the short points that I would make is that the situation in this case is clearly different. It's not the same as the kind of situations where section 31(2)(a) can be deployed in planning cases, where there is a counterfactual immersion into a decision-making process that's already occurred. You've been through the cases with planning, you've got considerations of buildings or public sector equality duties, but it's within the context of a decision-making process. That's a different scenario to this situation where you're looking at the question of whether section 31(2)(a) applies, where there's a question of statutory construction with a binary answer in relation to the conduct complained of. For the court to then go beyond that to a completely different legal landscape and make a judgment exposes the very serious tension between the more hands-on approach that section 31(2)(a) permits, but the more hands-off approach that must be taken by a court in terms of the constitutional differences.
So your essential point is that, assuming against yourself that we thought, in agreement with the Upper Tribunal, that your client's Article 8 claim is absolutely hopeless, there's nothing we can do about it.
For the purposes of section 31(2)(a), I say that is not the correct provision, but in any event, even if it can be brought into play, I've made my submissions on why it's not hopeless, because in the context of this case, the problem with Upper Tribunal judge's observations on Article 8 was it was focused on aspects of an Article 8 claim that were clearly inapplicable to the applicant's case. He was more focusing on his private life rather than a family life, which didn't exist. And he wasn't contending it existed. His case was about the length over 20 years of being in this country and whatever deprivations he suffered and the need to return here. That's a different scenario. That's a scenario that Article 8 involves. And going to the point that Lord Justice Dingemans raised earlier about materiality, that feeds into materiality as well, because if the focus has been on the wrong aspect of the consideration of what would be hopeless, then that's flawed in terms of a consideration regarding materiality. Those are really the essential points that I wanted to make, and I obviously rely on the submissions I've set out in more detail in the skeleton with the various grounds and the headings.
Yeah. All right. Well, thank you both very much. This is wet towel around the head time, I think. So we will reserve our judgments. You will get a draft in the usual way, which is your opportunity to correct our English but not our reasoning. We would hope that in the light of the drafts you will be able to agree on order, and for that purpose and that purpose only, the judgment can be shown to those who are on the distribution list. If you can't agree on order, please make short submissions in writing and we will make the formal order that we think is appropriate. The eventual hand down of the judgment will be done remotely by release to the National Archives and emailed to parties on the distribution list, and there will therefore be no need for any further attendance. Thank you both very much.